Any mention?
Please, my lords, I beg to mention item number 3.
Yes.
My lords,
The board has not been constituted yet. The board has not been constituted. Oh,
That is that appearing for?
the state
He says for the petitioner.
for the petitioners, my lord.
Board could not be constituted because the CEO has gone on some training. To the end of December will come. Thereafter, I think he will constitute.
When shall we fix it?
Yes, my lord.
When do you want it then?
End of December next year then.
No, we'll have it after 3 weeks. Yes, the request of the petitioner. Disseminate after 3 weeks. We'll see what happens.
I'll say that. If anybody.
Yes.
Right,
Watch.
my lords.
May I please, Lordship? I beg to mention item number 5.
Yes.
Lordship, in conducting constitution is not keeping well. I humbly pray may this matter take up after 2 weeks, Lordship.
Yes, to the appellant. This is matter after 2 weeks. Yes.
Not so, Lordship.
Please, Your Lordship, I beg to mention item number 4.
Yes.
Your Lordship, since my senior is not keeping well, Your Lordship, fix this matter after 1 week.
No objection.
This is also the request of the petitioner. This is matter after 2 weeks. Yes. Yes.
Item number 1.
Yes, Mr. Aditya.
Please, Your Lordship. The case is Nokmarship dispute between the petitioner and the respondents, particularly respondent number 4, my lord. That the brief fact of the case is that one Mr. Jongshan Momin was the Nokma of Nankra Aking lands since 8/4/1958, my lord, and he was continued for the Nokmaship. In the meanwhile, his wife was expired in 1964, my lord. Thereafter, they have this clan people has given a substitute wife on Ringme and Marak, but she also fled away with another man. Thereafter, the clan people has substituted another wife, Srimati Rane and Marak, and he has been continued as a Nukma of the Nankra Aking land, my lord. In the meanwhile, what happened, my lord? The respondent number 4 for submitting some document that the Jongshan Momin has relinquished his Nukmaship in favor of Alipshan Marak and Mene Marak, my lord. And on the basis of some other letter also, my lord, and also the report of the Mojadar submitted the application to the Royal District Council, my lord, before the EM. EM has passed an order in favor of
For
him.
appointment of new Nokma.
Then White order dated 23rd July 1976 passed an order.
You have submitted a list of dates and events, isn't it?
Yes, my lord.
Where is that? It's chronological events, isn't it?
Yes, my lord. This one, synopsis. And page number 32 and 38, my lord. In synopsis. And only the last para, my lord, last two para.
Anyway,
order.
then what happened? Yes, after this thing, you relinquish the right in favor of some new person.
Yes. Thereafter, what happened, my lord? Thereafter, the alipsant, junction momin.
Now, what respondent number 4 has to do here?
Here, my lord, respondent number in favor of the respondent number
So, Jongsang Mara relinquished the office in favor of the respondent number 4.
4.
Thereafter, respondent number 4 approached the district council authority.
And district council authority given a order in his favor as a nukma of Nankra Akhing Band. In page number 41, my lord, in synopsis, sorry, my lord, 33.
Of the writ petition.
In the synopsis, my lord.
What is this? This is.
Written argument.
Is it? No, what is this? Just show. What is this?
No, my lord, it is not, it is chronological even, it is not required.
No, but then give it, return it, because it is from court document. You cannot keep it.
Not required.
This is giving you from the court records doesn't mean that you should keep it.
How it is applied?
Definitely it has come from you, I think. Writ petition, I am holding a writ petition. So. There is a written submission here. You have stitched it. This is not in the court. Written submission is separate. There's so many papers, Mr. You are referring from your
Synopsis, my lord. Accumulated all the document together.
the synopsis filed on which date? How many synopses are there?
Yes. It is on the
There appears to
8
be
November.
there appears to be more than one synopsis here.
Yes.
There is a written argument also. One written argument, then another written argument.
No, that is not
is
my
by
argument,
Mr.
my lord.
Kitty
That is argument filed by the respondent number 4, my lord.
Yes. You filed it on 10th August.
Yes,
No. Why so many? Then there is again a synopsis. Then again another synopsis.
synopsis has been filed on the order of the court, my lord.
There are two synopses. That is the main thing. It appears from the record that there are two synopses.
Maybe given two.
See, where the facts are lengthy, definitely court asks for, say, like a chronological list of facts and events. That
That is not required, my lord. That is synopsis we have filed.
written synopsis. I think there are two copies. Anyway, yes, page
Page number 33, my lord.
of the synopsis.
Yes.
So you will refer from the synopsis. You will not
Yes,
need
my
to
lord.
go to the writ petition.
No, my lord. Because in the writ petition, all the documents are not closed.
See? Which one you are referring to?
A synopsis.
Which one? Which is synopsis? Which date?
In
There are two
November
synopses.
last year.
There are two synopses.
This one.
8 November. Okay.
Before that also there was a litigation between the parties here.
Huh? Yes.
He came to High Court before also.
Yes, my lord.
There. Anyway, yes, page 33.
Yes, my lord. Then in the last two paragraph, order, my lord.
Yes.
After relinquishment of Nukmaship, Jongshan Momin married Rane Marak Misik at his own will. The clan people of the Nokma did not give him substitute wife. The woman whom he took as his wife is at his own will does not belong to the ancestral line of Nokma family.
Yes.
Jongshan Momin not only gave up the Nukmaship, but he married another woman who was not belong to the ancestral lineage of Nokma family. So the Jongshan Nokma name should be cancelled from the Nokma register. Jongshan Momin thus vacated his Nokmaship, and in the vacancy caused thereof, Alipson Marak and his wife Mene Marak are appointed as Nokma of Nenkra, Arthingland, with effect from 23rd July 1976. Enter their name in the Nokma register, GT, etc. I order so as to stated above, my lord.
So why two different dates are down below? On the right hand side 23/7/76, on the left hand side 3/8/78.
That is the date of issuing the certified copy, my lord. Copies and read by as well.
Yes. Okay.
Here, my lord, one thing is that Mene Marak is not the daughter of any Nokma.
No, that is okay. There is also, so far as the Junction is concerned, he is gone. He is gone from the picture.
Oh, yes.
So who is the petitioner now here?
Here, my lord, Rick Boni. Now it is coming after the chronological event. It will come later on, my lord. After passing this order, my lord,
Yes.
Jongshan Momin has challenged this order.
He challenged his order.
Yes.
He relinquished the thing and then again he challenged.
No. At relinquishments, they have manufactured all these documents.
So he did not relinquish.
Yes, my lord. They have manufactured these documents.
Yes. Then?
So it has been challenged by the Jongshan Momin, my lord,
Yes.
in the court of chief executive member. And the chief executive, Jongshan Momin and his wife Rane Marak, both of them filed the case, my lord, of it against this order, 23rd July 1976.
Yes.
And chief executive member has set aside this order, white order dated 3rd March 1978.
Where is that? In which page?
No, it is that order is not there. It is reflected in the High Court order, my lord.
No, but then where is
Yes.
a copy of that order?
That actual order, it is not there, my lord, in the possession. It is mentioned in the High Court order,
It
my
was
lord.
set aside on what ground?
Ground is that these clan people rightly given him a substitute wife, number one. Number two is that Mene Marak is not the daughter of any Nokma, and the document they have submitted before the executive member, all are manufactured document.
So
As
this
per-
was set aside by CEO.
Yes.
Just a minute.
And
Just a minute,
thereafter, what happened,
Go
my
slow.
lord?
Go slow. Wait. Please go slow. Where it is reflected that it has been
In the High Court order, page
Where is
number
that?
34, my lord.
page 34.
Yes, my lord. Para 2, second paragraph, my lord. Page number 35.
Yes.
Shall I read out, my lord?
Just a minute.
A convenient starting point for the aforesaid narration of the relevant facts would be the date of the earlier order dated 23rd July 1976, passed by the learned executive member in charge revenue GADC in case number such and such, by which the Alipson Marak and his wife Mene Marak Misik were appointed as Rukma of Nankra, England. The aforesaid person who were appointed as the Nukma are the predecessor of the present respondent number 1. Against the aforesaid order dated 23rd July 1976, passed by the learned executive member Wan Jongshan Momin, here my lord, and his wife Srimoti Rane Marak, filed the miscase number 12 1977-78 before the learned chief executive member of the district council. The learned chief executive member of the district council prepared and signed the judgment dated ato, declaring the appellant Jongshan Momin and his wife Rane Marak as the Nukma of Nankra Akin. However, before the judgment would be pronounced. That is my lord.
Yes,
So-
that continue.
Yes.
That district council, he was judgment in the corner means what?
Yes.
However, before the judgment could be pronounced, then what happened?
Yes. The district council has superseded
Was
and an
superseded,
administration
okay.
was
Yes.
appointed.
Yes. Then
Thereafter, as the judgment was not being pronounced, the matter reached this court in civil rule number 478, which was disposed of by this court on 12/8/1979, directing the chief executive member of the district council to decide the appeal in accordance with law. Thereafter, by an order dated 25/3/82, passed by the administrator of the district council, a decision was taken that the order recorded by the previous executive member 3378 should be pronounced, and accordingly the same was pronounced.
okay. Yes.
So, my lord, thereafter, being aggrieved by this order,
Yes.
3/3/1978, my lord, these respondent numbers, here is now respondent not here, my lord, the father and the mother of the respondent number 4 file and read petition before the Guwahati High Court, my lord, challenging the order 3/3/1978, my lord. However, the case was withdrawn without any liberty and case was dismissed by order 5/3/1892, my lord. Give me the-
5/3/1892.
Yes, my lord.
Now the order which you have read just now
Ah,
at page 34.
yes.
Now what is this?
That is this is the order, my lord. That is they have filed against the order of the district council, my lord.
Achha, against that 3/3/1978, it was challenged in civil rule number
Yes, my lord.
against the order
Yes.
of the chief executive
Member.
by which he set aside the executive member's order.
No. It is not. Yes. No. It is not set aside. That is the set aside. That is reflected. Set aside the order of the executive member, my lord.
That is what
It is reflected in the High Court order, my lord.
no, that is we have seen.
Yes.
Now that 3/3/78 order was challenged or not?
It will come later on, my lord. I will go to that point because this
We
executive.
should have made a chronological list of dates. We do not know. It's very difficult.
No,
This
that
is-
order
this
is not there, my lord. That is the reason I am referring from here only. This order has been, one order has passed in favor of respondent number 4 on 23rd December 2003, my lord. That order has been challenged, and in this order, that order has been reflected, my lord. It will come, it will be clear, my lord. That is Against this order, there is a previous Nukma, Shuranankra Marak has filed this case.
What is the order which you are challenging here?
Here the order I am challenging is
Just come to take us to that order.
yes, my lord. Challenging the order in the writ petition, my lord.
That is in the writ petition.
Yes.
It is not there in your synopsis.
No, no, my lord.
Page 137, my lord.
Because instead of going like this, you get this picture here.
137.
130 something, Mr. Day, what did you say?
137, my lord.
137, my lord.
This is a type copy, my lord.
Yes, yes.
Type of
Instead of narrating in such a way, let us just see, come to the order and just let us see what is this.
Before going to the CEM order, my lord, I would like to request my lord to go through the EM's order. EM
See, from here it will be easier for the court to gather the facts.
that is what, my lord, from the EM's order,
Oh, yes, where it is?
and it is on page 23, my lord,
Of the writ petition.
of the writ petition. And this is one of the best EM order that I have read, my lord, of my 19 years. my lord.
That may not be best for Mr. Hadi.
That's why he is not taking my lord.
Anyway, let us just see first. Just we want this court is interested to get the facts.
23, my lord, page number 23.
Page 23.
Yes.
Now that is not legible here. We have to have a typed copy.
The type copy, my lord, they have not enclosed, and there was a direction.
Page 23 is not legible, Mr.
This, my lord, there was an order also of this honorable court, where, my lord,
we have submitted it.
the type copy.
Typed copy of this.
Yes.
Where it is?
It will be exact copy of this order that
No, they have given a type copy of the CEM's order, but EM's order type copy they have not given, my lord.
No, this is not legible. This is not at all legible. This is again a problem. You see.
These need to be typed, my lord. It is difficult to read. For CEM's they have given. No, they have 2000. I have not seen.
Yes, Mr. Hazarika.
yes.
You have to type it out. Just see.
Okay, my lord. I will.
So this is, you should have typed it. This is, if you know this is relevant. See, all the pages, not only one page, none of the pages are legible.
And the first page is slanted.
By tomorrow itself, we will submit, my lord.
Hmm?
By tomorrow itself, we will submit the type copy of this order.
You may submit it tomorrow itself.
This order is, my lord, is
have it?
passing in favor of me.
That is all right, but then we need to go through, if we have to determine the facts.
Yes.
As Mr. Dey says, that the fact will be clear if we go through this.
Yes.
So this
Yes.
is,
So that is.
this is a case, the EM's order
Yes.
was interfered by CM. Is it a case? It's a case of reversal.
Yes. Now here, my
Not
lord.
exactly.
No.
Not
Now I am going in short, my lord.
Just say in.
No, I am coming to that point, my lord. I am coming to this point. Only thing is that after passing the order 3/3/1978, they have challenged it in the Guwahati High Court, which has been withdrawn by the respondent number 4. parents of the respondent number 4. And Jongshan Momin and Rane Marak has been continued the Nokma of the Nankra Acting land since 1991. In 1991, what happened, my lord? That plain people has selected Sura Nankra Marak and her husband Shimran Tin Shangma as a Nokma, my lord. Because during that relevant period of time, the present petitioner here, my lord, Rikmoni was very small, very young age, 7-8 years. So they have plain people have selected him and they have made them Nokma in 1991. And that case that they have filed in the district council, then district council passed the order on
See, in district council in this page 23, who is the petitioner?
here.
Sora Marak, Simran
Yes.
Momin,
Yes.
they are the petitioners.
Yes.
So who you are representing them, isn't it?
Yes.
Now you are the petitioner. So why did you approach this executive committee at that point of time? Against what action?
No. What action? That means here what happened, my lord? They have selected me, Sura Nankra Marak and Shimran P. Shangma. Then they have filed the case before the district council.
Why?
To recognize them.
So
Recognize them as
who selected you?
this clan people.
Okay. After clan paper selected you,
Yeah, selected.
then you
yeah,
approach the
forwarded.
district. Yes,
to
yes.
the-
Let us go slow. Let us go slow.
Yes.
After they selected Sora Marak and Simran Momin,
Yes.
then they approached the district council for issue of necessary order in their favor, isn't
Yes,
it?
approval of the.
Now from that this has arisen.
Yes, the
It means
appeal.
once you approach the district council, the other side objected.
Yes.
Is it?
Yes. After hearing both the parties.
So that is what just come to this thing.
Yes.
Let us just understand. Okay. That means this executive member he decided the matter in their favor,
No, in my favor.
in your favor. So this order says that you are the Nokma, isn't it? You should be
Yes.
appointed as Nokma.
Yes, ma'am.
And then that
Then-
was challenged by them.
And this order was challenged by respondent number 4.
Now
Respondent
before
number.
the chief executive member.
Yes, ma'am.
Now chief executive member, what he did?
No, he has passed the order in their favor.
So that means this order was set aside.
Yes.
Executive
Yes.
EM's
Yes.
order was set
learned-
aside. in
set
favor.
aside.
my learned senior friend
And then
is
there are-
making a hodgepodge of the entire issue.
See-
Now, if he is representing Sora Mara, and then who is Rikmoni? Rikmoni is also a petitioner in the appeal. My lord, may kindly see the order. That is type copy in 137. Rikmoni, he is representing the Rikmoni. Rikmoni is the petitioner.
Until unless this court gets fact.
That
see,
is
it
why, my
cannot
lord,
be
I
decided.
have
no,
suggested.
here, my lord, what
Cannot
happened?
be, see, that is what the problem is. See, that is probably why this court wanted synopsis and all. But then even after submission of synopsis and all, if this.
No. Here, my lord, what
See-
happened? After that, these.
Just a minute. One second. Now you come to page 23. There are 4 petitioners and 2 opposite parties,
Yes, my lord.
isn't it?
Yes.
Now,
Now
on the
in the appeal,
Ah.
there are 2 appellant and 2 respondents, and none of them seems to be the party to the original proceeding. This first
Yes.
how you clarify it? The Sora Marak, Simran Noming, they are not a party to this appeal.
No. It has, they are the party, my lord.
How their name is not reflected there? How you say they are the party?
No, that order is that.
See, Mr. Hazarika, probably you see like you have not done enough to clarify the things here.
No.
You may be, these things may be clear in your mind because this is your case.
Yes, my lord.
But then there is, see, if until unless those things are cleared, how this court will understand?
This order, no. Then thereafter, I am coming to that point, my lord. I am coming.
Yes, Mr. Dev, how it happened? There are
now that
Court
is what, my
petitioners.
lord. He need to clarify how Rikmoni comes into picture, and from where she is deriving the power to become the
see
Nokma.
this Rikmoni and Benin Momi.
Yes, my lord.
Both of them, they are not a party
In the
in that page 23.
yes,
isn't
my
it?
lord. Yes. Now,
And
page 20.
Again, come to the respondent also.
Yes, my lord.
Madalin Marak and
Yes.
Herbert Sangma.
Yes.
They are also not party.
Yes. Now, from Sora Nokma, just a minute. From Sora Nokma, how Rikmoni is deriving the power? What is the role of Rikmoni? Or who is she? My learned senior has to apprise this honorable
Yes,
court.
I will
Sora
apprise.
Marak is no more alive or what?
No. They are saying, my lord, she is a minor. Just now, he has given a
No,
submission.
in 1991, my lord.
Now, if she is a minor, and
that
if
is
she
the
can be
claim.
a party in the first round of litigation, why not in the appeal?
That is what, my lord, they have to justify this. Why? Now, if that is the case, my lord, then my learned friend's client has no locus also to file an appeal before the CEM.
And Sora Marak is still minor or what?
No,
That is what
a
he has
major,
to-
my lord. Major in S. Then they have
Who are the petitioners here in this case? In this present matter, Sora Marak is a party, yes.
In the
Suramarak is expert.
In this writ petition.
writ petition, she is not a party, my lord.
Why she is not a major till now?
No. Whom, my lord? Sura.
Sora.
Sura is already expired, my lord.
Just not, my lord. That is what, my lord, he is not even in a position to say.
No.
My lord, just a minute, please. My lord,
No,
if I can pray, my lord.
It seems things are not very clear. I think something is hidden.
My lord.
No, my lord. It is not in that. Here, my lord, what happened? I am telling in brief, my lord. If my friend will stop, then when in 2015, 2003, my lord, that order has been challenged by the Shura Nankra Marat and this Shimran T. Sharma. While the case is challenged in the High Court, my lord, while in the case is pending in the High Court, in the meanwhile, Shura Nankra Marat was expired, my lord.
When
When
case was pending at what time? You you know what you are saying, Mr. Hazarika. This court is not getting anything. Just do not divert it. You just tell us that the first matter before the executive member, there are 4 petitioners.
yes, the Kalen people also will fight. Yes.
And then how come those people were replaced in the appeal against the same order?
Replace in the
See, come to page 23 of the writ petition.
yes, my lord.
See how many petitioners are there?
4.
Oh, then come to page 137. Now this 137, is it an appeal against that order?
137. I know.
No,
No.
not exactly.
Then
This case was remanded back by the High Court, and then, my lord, the appeal was initiated. my lord.
anyway, case
That-
was remanded means
Yes,
its appeal arising from the same order.
from the same order, but with certain modification, my lord. These facts are not narrated in this petition,
That is why the court is confused, you see.
and that is why, my lord, if I can just humbly submit, my lord, let my learned friend, my lord, give a type copy of the EM's order. Second thing, my lord, I will make a sketch, my lord. There are so many names, my lord, which will create confusion, my lord. A sketch map has to be made, my lord. Who is coming from which side, my lord?
Exactly.
That is what he is supposed to submit in a synopsis, but he has not done, my lord. So I will do it, my lord. From this record, my lord, I will do it.
Now, my lord, that type copy of this order, my lord, 1712-2000, it is there in the synopsis. In my synopsis, it is there.
Synopsis also true, my lord, which he is referring also, that is also creating confusion, my lord.
Where is that? Let us see.
No, it may be
Let us go to
confusion
the-
for you.
It is do not make this court confused. See, if you make this court confused, then court will find it out. It is not that the court will not be able to find it out, but then it will be time taking. Nothing else. You see, if you if you have submitted synopsis, then it is always better. Here everything is not there in synopsis. That is why you have to come to writ petition, then again go back there.
No, my lord. It is only the order, judgment and order, 15/12/2016 is not in the synopsis, my lord. And other things are already enclosed in the synopsis.
You see, synopsis was there for convenience, isn't it? It's not for causing inconvenience.
That we
Where
are
is that
seeing-
order? At what page of the synopsis?
This is a page is 60, my lord, 60. type copy.
Yes, let us go through this. Let us see.
Yes, sir. Synopsis.
Starting from 62 pages.
Yes.
What my learned friend from JCTC was saying was correct. Actually, there was a chronological event was filed. Actually, my learned friend petitioner is not aware. It was filed on the 25 June 2019. Maybe I don't know whether that court has a copy. But here in the chronological event, the history, they said that the history chart number 1, because everything was given as my learned friend was saying. He was trying to see that map also was given for him. Yes, he was given the chronology, how it has come, the history of the case in the gist. This is the one filed by the private respondent. But I don't know whether if that code is not there, we can produce it. It will be good for four of us.
Without this table,
Yes.
my lord, without this table, it will be very difficult to understand how Rick Money comes into picture, my lord, and where Sora has land up now, my lord.
Another thing is because in the repetition,
Only thing is that money is come into picture when case was pending in the before the Honorable High Court. Then the claim people selected the Rikmani and her husband Benin Momin as a Lukma, and they are substituted in the High Court, my lord, because Surah Nankara Mara was expired.
What you are holding, Mr. Sangma? That is a genealogical tree or what? What is
No, it's a table. It was just made by us, my lord, for the easy reference of this honorable court. With this, my lord, it will be easier for us to explain.
Here.
We can supply, my lord, after verifying the
Is it submitted?
as per the here in the report, it was filed on 25 June 2019. Is there? But maybe mistake. Because copy might have been
If something is submitted, it always remains. Nothing goes missing from the record.
And one thing, my lord, because in the petition, this petition itself is incomplete because they have hide many things. They have concealed the fact because many documents order was not submitted chronologically.
That is what the problem is.
No,
You see,
because he is making submission from here and there. It is so difficult. And thereafter, even in the other bench also, this matter was before the Justice Dingdu, and Justice Dingdu has asked the petitioner to file all the synopsis, including all the list of date, everything in a chronological, so that court can understand. But then he has filed it, but he has not filed in a chronological way. List of date, everything.
there is a note made by Justice Diengdo in this matter. It seems like court has made several notes, but then could not get it.
This matter was
Yeah,
heard,
many
my lord.
pages.
It was heard for.
if these things continue like this court also will not get
And
anything.
moreover, my lord,
No.
if I can just point out to this honorable court, my lord. Now, my lord, whatever has been submitted, there's no pleading to that effect. How can we reply to that, my lord?
No. Here, my lord, we have filed the synopsis.
This is not an MPDA petition,
we
my
can
lord.
understand. We can understand, Mr. Hajarika, filed a synopsis, but then we are
Synopsis
not
cannot
been able to
improve
make
the
out
case,
thing
my
from
lord.
the
No,
synopsis.
because we have enclosed all this order, my lord, before it
See,
was not there.
Mr. Hajarika, you know the
Yes, yes, my lord.
things may be clear in your mind.
Yes.
We do not know. Now, when you place it before the court, if it is not clear, then it is very difficult.
No, it will be, I will make
So
it.
anyway, I think this order will throw some light, which Mr. Day has pointed out.
Yes, my lord.
I think this will throw some light
Yes,
so far
my
as
lord.
the actual background.
Yes,
is
but
concerned.
before, my lord.
Now, simply it's a case. Basically, is appointment of NOCMA. Isn't it?
Correct, my lord.
Now we are sitting in a judicial review
My
226.
lord, yes,
Our jurisdiction is limited.
my lord.
Now, what is the ground raised in this case? What is the ground on which you are seeking? It's a case of reversal, isn't it? The executive members' order was in their favor.
Yes.
Yes, my
In
lord.
petitioner's favor.
Yes.
The chief executive committee reversed it.
No, not exactly reverse, my lord.
Yes.
Now, in between, my lord, the petitioner died. Sora Nokma died
During the pendency of the appeal.
during the pendency of the writ petition. They came into
Just tell
picture.
us what is the cause of action for filing the writ petition?
The,
If this executive member's order was in their favor,
my lord.
okay, and it has not been
Subsequently-
interfered with.
Subsequently, my lord, there was lots of litigation in between, my lord. That has not been brought, my lord.
No, it is there, my lord. In
Okay,
the
so
manual. It is.
Just a minute.
Yes.
Otherwise,
we are
my
trying
Yes,
to
sir.
get it. See, we are not deciding. We are just
Yes.
trying to get the facts. Mr. Hajarika,
Yes.
that means after passing of the order by the executive member, and by the time the appeal remained pending, was there a lot of litigation between the parties before the High Court?
No, my lord. It is gone serially, my lord.
So that is what said. How do we know that which date first case was filed and then when it
No,
was disposed of
my
and
lord.
then which?
If you go serially, my lord, one after another, so matter will be more clear.
See, for going serially, we do not have to, you see, like read 3 page for the first part, then another 3 page for the second part. You see, so far as the chronological facts and events,
Yes.
it should be there in a simple 1 page thing. The first case filed on such and such date, case number decided on such and such. Appeal filed on such and such date, decided on such and such date. So that way, if you do it, then things becomes in 1-2 pages. We can at least get overall picture. Then you give your narration.
Because in a
There will be more than 15
No,
orders. He has annexed only 4. That's my learned friend.
See, this court basically is interested to know
Yes.
what is the controversy involved in this. Till now, court has got nothing. Only except getting that there was a dispute between the parties in so far as the office of NOCMA is concerned. Nothing else.
So, Lordship, what we are trying to assist the court is because the petitioner he has narrated the event chronologically. Number one, number two, he has concealed. Oh, there are a lot of litigation.
Until unless those are brought before this honorable court, my lord will not be in a position to get the gist, my lord. What is the background? How Rick Money came into picture? Now, if my lord, Rick Money has no locus, my lord, to become the NOCMA, that is why it has been reversed, my lord. Reversed to that extent, my lord, not setting aside the order of the EM, my lord, totally. Now, in between, after my lord, Sora NOCMA was declared as a NOCMA, my lord, then there was lots of litigation, and it came to this honorable court also, my lord. Then
That is where this is where are those facts.
it's not there, my lord, and it's not even stated in the writ petition, my lord. So now, whatever submission.
What is Mr. Hajarika's case? Mr. Hajarika, what is your case here? What do you say? What is your ground of challenge?
ground of challenge is that we are directly from the Nankra clan people, my lord. And this Madeline and her mother was not the daughter of any Nokma. And now this present writ petitioner is the daughter of a Nokma, Rane and Marak, who is the substitute wife of...
What is the finding of the authorities below?
No, authority, we have filed the case. They have given in our junction mobbing and my father and mothers in favor of them. So they have continued up to...
That is a thing of past. Then why you are aggrieved then?
After that, my lord, when they become as they have relinquished the junction mobbing and Rane Mara for old age, then Nokma, that's sorry, my lord, these clan people decided and selected.
There
No,
was, it
in the
means this
meeting-
Johnson basically relinquished his office.
Yes.
Which year?
He is from 1958, my lord.
No, when did he relinquish the office?
1991, my lord.
So you said that he has not relinquished.
No, after that, my lord, when he is relinquished because of old age, these clan people.
After that means when? It means he relinquished twice.
No, before one to it is challenge.
Okay.
Before
So
one
there
to,
was no relinquishment before.
for no
So
relinquishment.
that is their allegation only. You relinquished.
They are allegation.
But then when did you admittedly relinquish? Just tell us.
No. Yes.
When Johnson admittedly relinquished?
Yes, in 1991.
Then when that did they allege that you relinquished?
Then they have.
That was in 78, 79.
78, 77, 78, my lord.
76.
Yes.
They said that you relinquished.
Yes.
On that basis, basically they were appointed.
The
But then subsequently you challenged it. You said you have not relinquished. So you came back to the office.
No. It is then Shura Nankram Marak was selected. They have filed the petition to the district council.
Why Shura?
Shura Nankram Marak is Simran Pisagma.
No. Why so long you were alive? Why that other person was selected?
Shura is the clan people, my lord. Because Shura is the.
Mr. Hajarika, it seems there is a communication gap between the court and.
No. I am coming to that.
See, like you say you are coming, but then you never come.
No,
we are just hitting around the bush. Now
Yes,
that is
my
the
lord.
problem.
I have to go serially, my lord. Then only.
So you give us a list of names. Then in such a case, who has stepped into whose shoes? How do we know? This year the court is not getting anything.
My lord, here in my written argument, my lord, it is more clear, my lord. Because Shura Nankram Marak come into picture in 1991. Then he was appointed by the district council in 2000. Then
Before Swaran Onkra, who was there?
Jongshan Momin and Rane
Why
Marak.
Jongshan gave up the office?
Because he is old age, my lord. Old age, thereafter he is expired.
So then where do we get the chart from where to who came?
Yes, exactly. Now,
Give us just the chart.
Okay, my lord, I will give the check.
This way will end up nowhere.
And 2003, then 2003 is coming to the Meghalaya. Then it has been challenged in the High Court. Their order was set aside. And again it has come to High Court. In the meanwhile, the Shura Nankram Marak was expired, then substituted by the Rikmuni and her husband.
Then where is that? Where is that?
That
Just give
is
us it in writing.
only
For
in the
you
order.
it is okay. It's by heart.
No, it is okay, my lord. It is it is reflected in the order itself.
Where is in which order?
High Court order. High Court order, my lord.
So then why you are taking here there? Then read the High Court order. Things will be clear.
No, my lord, I am not going in the serially. So
you are not going serially. High Court order is not serially.
no, because one after another is coming the order, my lord.
If you say High Court order reflects all the facts, you do not have to start from the beginning. Come to High Court order, you will get the entire picture there. So we can finish it without asking you do it again.
Then,
This way you will never be able to finish these cases.
if I can just submit, my lord, the core issue before this honorable court, my lord, whether the substitute wife's daughter has any claim about Nokmaship. That is the core issue, my lord. Whether the substitute wife given to a male Nokma, maybe it was given legally or illegally or he married by himself, that is not a question. Whether the wife, substitute wife, daughter has any claim or not. The law says
He is the daughter of a substitute wife.
substitute wife. Now, my lord, the law is very clear. A substitute wife will have the right on the Nokmaship till she is alive, my lord. Thereafter, the daughters,
Till
she is alive. Like till she is alive, she will enjoy the Nokmaship, my lord. The moment she died, my lord, her successors, my lord, will have no right. It has to be reverted back to the Nokma's sisters.
Successors cannot inherit that right.
No, my lord. Until
That is what the law.
that is the law. There is a certain law, my lord.
There is no
His
such law.
claim is based on this.
Yes, my lord.
There is
That
no
is the
such
thing,
law.
then we can finish it in shortcut without going much.
Yes, this is the fact, my lord.
Here, what?
There is no such law.
Contention lordship.
No.
Yeah.
And moreover, this
You see, if you speak together, then
Yes.
just
Just want to clarify that. Actually, here we are saying that Hajarika's client is not even a substitute wife. Here, what's the case? I have clearly mentioned in my written argument, para 3. He said this Johnson, he has admitted, Johnson has relinquished his Nokmaship. It is there in the record also. And it was approved by the CEM and the EM.
See, we
Now
may
let me
not-
just complete my lord. I just want to
see.
complete
You see,
what
if you
I-
complete, do not complete, you will have
No,
no bearing.
only-
We will not go into venture
Yes,
into factual
lordship,
aspects.
But only what I'm trying to make is now, after relinquishing, the Nokmaship was relinquished and allow me to become a Nokma. I'm the real I'm the daughter of the first wife of Johnson. Johnson, he relinquished and he left the family of my parents, my mother. After leaving my
My lord.
family, he went and get married with some other lady. Now, once Johnson get married, relinquished us, and he's in the record. He said that my son-in-law and daughter can be a Nokma instead of me. That is also in the record. So, on the basis of his relinquishment, we become the Nokma. We were appointed, and after 10 years, he left our family. He left my parents, my mother. He left. Then he went. He left the family and means like divorce type.
You said that he has left the family,
Yes, left
then
the
he
family.
relinquished the office.
Yes.
You entered into his office,
Yes.
and then he continued for 10 years.
Yeah, no. After 10 years, he get married with some other lady. That lady's daughter is Rukmani is the daughter of that second wife. Means like who is not substitute illegally. Means
No,
like,
see, the thing is that you say that he relinquished his right,
yes,
and in his place, you stepped into his place.
yes, lordship.
But then the thing again, he after getting remarried, he came back, isn't it?
He will never come back. Never come back.
Then
He
how
never
he
came to the
then
family.
how he became again?
Now that is the core issue. He-
How long you continue as Nakma after he relinquished?
No, we have been continuing even till.
He said he had not relinquished.
No, it is there
You
in the
say-
record.
That is why that is cutting short to my friend.
So we are, but then we are not going into those controversies. You see, we
My lord, whether he has relinquished or not,
quite some years back.
my lord, whether he has relinquished or not, my lord, is irrelevant now.
Definitely.
The case is this, my lord. Even he has not relinquished the place, he was given a substitute wife. Now, whether the daughter of the substitute wife has any claim over the Nokmaship, the law is
Now,
settled.
see, the court's query is that prior to the dispute which arose in 2000, when this executive member was approached, who was in the office? Who was in the office of Nokma?
I was
No.
You were in the office.
Lordship. Till now,
Undisputedly, you were there in the office.
Your Lordship.
He challenged your continuation in the
Nokma.
office.
Even now also I'm not.
Wait.
Yes, Lordship.
Please answer the
Sorry,
query.
Lord.
So he challenged his appointment,
Nokma.
your continuation.
Yes,
It was interfered with by the executive member.
Lordship.
Then you challenge it before?
Before the High Court. Then,
Direct from executive member.
no. From executive member, I want to see
Who challenged before CA?
before CEM. Actually, the EM order was in my favor. Then CEM was in my favor. Then finally, he has.
So EM, CM, both are you are
Yes, in my
successful.
favor.
Then against that he has come to this
Yes,
court.
Lordship.
So we are dealing with that.
Yes, with that. Now he has to.
Is it correct?
That is the
No, man.
This is not correct.
So that is
It's difficult. So
The
we are,
impugn order is there, Lordship. The impugn order is there, Lordship. The very order that he is challenging
let us
is
see.
consists of.
Let us come to the writ petition. We will not go here there. We will just confine
Yes,
to
that
the-
is in his petition, Lordship. Yes, we close it.
What is your prayer in the writ petition, Mr. Hajarika?
There is page number 16, my lord.
The pages of the writ petitions are gone. How to read it? Please read your prayer at page 16, please.
In the premises aforesaid, it is most respectfully prayed that your lordship would be graciously pleased to admit this writ petition, call for record from the learned court below, the learned court of CM Tura, issue a rule calling upon the respondent to show cause as to why a writ in the nature of mandamus or certiorari and or any other appropriate writ, order or direction should not be issued, directing the respondent not to disturb their peaceful possession of Nankra Aking land, and or as to why the impugned judgment and order dated 15/12/16 passed in appeal number 44A 2014 by the learned court of chief executive members GSA DC Tura should not be set aside and quashed, and or why the order passed by the learned court of executive member IC land and revenue data 70 data should not be upheld, and or as to why the incident case should not be referred back to executive member IC land and revenue GSC Tura for de novo or fresh trial of the case and decide the same as per Garo customary law. In this
So
practice-
your thing is confined to this thing.
yes,
Challenge is 15/12/2016.
yes, madam.
Where is the 15/12/2016 order? Come to 15/12/2016 order. We'll just see what is there.
Page 137, my lord.
Just read that order. Let us see. What is that order of the High Court dated 23/9/2014?
Yes, madam.
Order of the High Court passed in writ petition number 25 of 2013, 29 of 2013.
13. I passed
Where is that? Order dated 23/9/2014.
2014. (29/3).
23/9/2014.
There is not enclosed in the writ petition, my lord.
No, we want to see this because this is it
that
seems
is
that the appellate
That
authority
was
has
the first question which was raised by the Honorable Justice Dingdo. That where is this order? That was not enclosed, my lord, in this writ petition. Probably he has filed in the synopsis, my lord. That is why, my lord, we cannot get the correct picture.
this is a huge confusion. That is why you see basically this court initially thought it will go into the depth of the thing.
It was
The way
what
councils
was
are moving, it's very difficult for this.
what was
court.
fallen. What was fallen from the other court, my lord. That let this matter be withdrawn and everything should be compiled and filed it, my lord. There is no harm on that, my lord. But that also he is not doing.
We'll see if there is more confusion to there.
This not enclosed. This order also is not there. High Court order also is not there.
It is not there, Mr. Hazarika.
Yes.
Where is that order of the High Court dated 23/9/2014?
Because somewhere because
That is why, my lord, we are so confused about this matter. We cannot get the gist.
You come prepared, you are not prepared.
My lord, may kindly allow me to make a sketch of the names, my lord, so it will be more clear, my lord. I will prepare it, my lord.
Mr. Day,
My lord.
the way things are going, court is becoming more confused.
My lord.
Now, without going here, there, we'll just confine
With
to the
writ.
materials on record and we'll decide the matter.
No, my lord, what I am
We're not going
suggesting,
here because the council submission is not submissions are not helping them.
my lord, what I am suggesting is this, my lord. In the appeal order, my lord, of the CEM, my lord, there are a number of names, my lord, and he has not given any statement from where Rickmoni has come, my lord. For that, my lord, I will just make a rough sketch, my lord. I will place it
You
on
can
the
make
time.
it, but then if something is not stated in the writ petition, this court will not go into all those things.
That
It
is for him.
unnecessary. It
That is
not-
for him, my lord. But
when
I'm just
counsels themselves are not, they do not know their case, why the court should be bothered about this. We'll just see what is the materials on record and what is the duty of the court to be done, and we'll do it.
for the easy reference of this honorable court, my lord. I will make the sketch map, my lord, with the names. It was supposed to be made by the petitioner, my lord, but they are playing.
Any action which helps the court to come to the actual question, definitely it is always welcome. But then the thing is that it should be done in this way. It is not for the purpose of confusing the court. Why this appeal remained pending for such a long time?
This matter was writ appeal, the CEM appeal.
CM appeal.
No, my lord, because there was lots of litigation in pending.
So what are those things? What happened?
That has not been brought on record, my lord. And we cannot make a statement because there is no pleading to that effect, my lord.
This is a problem. This is about there is a more than a decade gap of more than a decade.
This matter was heard more than 30 times, my lord, by the Honorable Justice
No,
W. Dingdaw, my lord.
if things go this way, if you do hearing 300 times also, that will not happen.
Definitely.
You can't prepare, Mr. Hajarika. Well, it seems you are not prepared. You take steps, whatever way you think that it will be easier for the court. And if you find that it is not done, then we'll just go confine ourselves to the pleadings. We'll decide the matter. Helpless, this court. You have tried. Not getting, there's no proper explanation why this, that.
Because of this case is from the long period of time, my lord. So that is the reason.
See, you say that things are clear. You say your synapses are clear. But then you yourself, you are not able to explain it clearly. When the court asks you what about the relevant orders, you do not know where it is. Just say it appears that the learned counsel for the petitioner is not prepared for hearing. Stop matter and standard zones, list of it. This is not a very good thing to do. Unnecessary.
Item number 2.
Yes. What is this, Mr. Sangma?
This also regarding Akang Nokma, right?
Again, very confusing matter. Do not move away. You see, this court doesn't have a very, you see, huge range of patience, you see. You see, sometimes if you do not get the facts, then it becomes very difficult, Mr. Mahanta.
In fact, we should have.
Especially when you find the counsels are not ready.
In fact, it's our duty to assist you.
The first petition, the original proceeding was drawn in one name. The appellate, before the appellate authority, the parties are totally different. And there is no explanation who came into whose steps and all those things. And it's a become a riddle, you know.
I think that needs a good burial.
Do not make it like this here. Yes, tell us what is here.
Yes, Lordship, I just to make it short, Your Lordship, the page, the order dated 24/06/2024, Your Lordship, where there is a court has court for the record, Your Lordship. Now the court has the learned friend from GHDC, they have submitted the record as per the direction of this court. Now, after submitting the
Why
record,
you needed record? Okay, that issues were framed
the
or
issue
not.
were framed or not. Issue
That-
were
that
framed
was
or
the-
not. Whether the documents were not were considered or not. Now the record has been submitted, and the court has particularly specifically asked the counsel just to submit a specific document. They have submitted the
Not
specific.
document, just
Yes, the record.
Yes, just point.
Yes, the record consists of 69 pages, Your Lordship. I have gone through the record, Your Lordship. After going to the record, some of the documents which is submitted here is the same which I have enclosed in the repetition also. Now the issue here is that after going to the record, I've learned it because here, particularly this document which he has submitted from page It will be from page 1 to, and then 1, 1, 1 to this one. Particularly this, I just like to draw this one. The page 10, page 10 till 12, my lord, the Annex 17. This was never never agitated, because they said this is document, this document page 10 to 17 is the document. Is written in Garo. All of them are written in Garo.
10?
Page 10, lordship. Page 10.
Of the classification of the relevant records?
Yes, or relevant record.
Page 10, from
Page 10. Page 10 till the page 12, the Annex 17. Because this is these are
No,
the,
you are referring to this?
the record.
Yes.
The record, they put it as Annex 3. I think they put it in the
Page 10?
10. Page 10.
Yes, yes.
This page 10, my lord, may be difficult to understand, maybe
No,
because
that is
it is
okay.
written
That
in
is all
Garo.
right. See, this code basically
Yes.
may not go into the contents
Yes.
of the document.
Yes. Now,
what basically matters most is that why you challenge this order of the CM, you primarily raise two issues.
yes.
One is that the no issues
Yes.
were framed,
Yes.
and the
No
second
issues
is
framed.
that wait, let us finish.
Lordship.
And second is that the documents on record
Lordship.
were not taken into consideration.
Lordship.
Now, if you can establish this, definitely you may have
Yes.
a case for interference.
Now,
Now, to ascertain that this record was called, now, what are the documents you want to say the court has not taken, the authorities below have not taken into consideration?
yes, Lordship, I'll come to that, Lordship. I have on the last occasion, my lord, I have filed a list of date and event. I will just go to that. So, list of date and event, because on the earlier occasion, court has directed me to file a list of date and event.
And you started from 1933.
Yes, I will not point out all this one, but I will just point out the date, and we will give a little small explanation to that.
But then why you are going to date? Tell us what are the documents which are not been
Yes,
taken
that's
into
what I am saying, that document which has not been considered by the EM and the CM of GHTC. First, number one, the genealogy tree. I said that since this Adukasor Akang has been in existence since
Where is
from
the genealogical
1933.
tree? Where is the genealogical tree? Which
It is
has
in
not
my
been-
petition, my lord. It is in the page 30.
Page 30.
Whatever I am relying, it is in the. I think if you go after page this one, there may be it may take some time. But here, whatever I have reflected in the list of date and event, everything is there in the repetition.
Let us come to the impugn order which you are challenging. Come
Your
to the
Lordship.
impugn order in the writ petition. You don't want to open a Pandora box.
Yes, it is page 157, my lord.
Watch 57.
I think it's 157. What 157? No, page no. Wait, this one. This is 150. Yes, 159. 159.
See, it appears that this matter was argued before also, isn't it?
Yes.
And it appears the primary points which you have raised, as per the earlier note of the court, is that no issue was
Yes.
framed. Number two, no statement of witnesses was recorded.
Lordship.
And number three, that no opportunity to use and utilize the documents.
Lordship.
So that is one.
That is.
Okay.
Yes. That is the point of contention.
So these are the things.
These are the contentions of the petitioner.
So now these documents were not considered by whom? The
Uh,
CM.
By this EM and the
EM,
CM.
EM order was in your favor. No.
No. Both EM and the CM is not in my favor.
So you have come against concurrent finding.
Lordship.
So come to the which order you want to take us first, EM or CM?
I did the CEM, my lord.
CM.
Lordship.
Now, CM is not the original authority who
Yes,
will
no,
frame
no,
the
no,
issues,
yes.
isn't it?
I
It is for EM to frame the issues,
Yes.
isn't it?
yes, that is in the page. EM order is in the page 151.
Page 151.
Yes. No, 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 this is the chief executive member. After that,
For you, what do you want to, for you, what is relevant? So far as your submission is concerned, which part you want the court to go into?
I want the order of the CEM lordship, page 159.
No, but then
just want to see
it is the duty is
Yes,
cast upon
Lordship,
whom to
let's-
frame issues. Do you want to say that both the authorities,
Yes.
EM and CEM,
Yes,
both should
go.
frame issues?
You should be set aside. Yes.
Have you got the question of the court?
Yes, my lord. But both the order
You are
of the
looking at something and find it.
Yes.
Find it.
both the order of the CEM and the EM and the CEM
You are relying on Dore Sangma, isn't it?
lordship,
Now Dore Sangma says that the issues should be framed,
lordship.
isn't it?
Yes,
And the
lordship.
decision should be rendered on each and every issue.
Yes, and there should be a
So this issue should be framed by whom? EM or CEM?
issue should be framed actually by the EM. By the EM.
So here it's a case EM has not framed.
EM has not framed.
Yes.
And the evidence also has to be recorded by the EM. And the document also has to be considered by the court.
Whether
of the
recording of evidence is mandatory.
EM. Because even in the
No, whether
yes,
it is
yes,
mandatory.
yes, it is mandatory, lordship.
Yes, where it is that, where it is provided that recording of evidence is mandatory.
Because
Which law says?
yes, you said that the recording of evidence. I asked my lordship
What-
find out
what
in
you-
the
what
in the
you-
court in the case of Dori Sangma.
Come, Dore Sangma, come. What is the principle later on in Dore Sangma? Let us see.
That order, not, but it's the page. The para.
You are relying on Dore Sangma. You do not have.
I have, but that particular order I have.
Mr. Mohanto, if he says it is correct, then we will remand this matter back.
No,
If no issue is framed or
not correct at all. Therefore, I'm here, Your Lordship.
It is correct because why? Because here, lordship, on the last occasion, they only for just to find out whether the issue has been framed, whether evidence has been recorded, whether the opportunity has been given, whether the other document, whatever enclosed, it is available, whether that has been considered. That was the issue. But in after, therefore, to clarify.
Anyway, come to the principle of the Dore Sangma.
Yes, lordship. Actually, I have to that.
According to Dore Sangma, what is the requirement?
I have zero cases.
It is there. It is not there.
Actually, lordship, I have zero certificate. I have the book also.
Anyway,
but
this court,
I did not bring
the court is having one copy. I think this paragraph 20 will be relevant. Just you can take it and
I remember the para also.
yes, just take it, read it from me, and then
But
return
at this
it.
moment, somewhere I
Just let
misplaced
us
it, lordship.
refresh what is needed.
May read only the relevant para,
Just see
para
whatever
20,
relevant.
Lordship. Yes.
Just because court has marked 20 may not be for.
No, I'm relying on that because
20, para
yes,
20.
yes, only on
Please,
that one.
please just read it.
Yes, sir. For all this reason, we should hold that the revenue member alone has the jurisdiction to decide a type of dispute, but then while doing so, the revenue member has to follow the fundamental principle of judicial procedure. This being framing of issues which has been regarded as necessary for court to get the grip of the case. See video this one, video Bindu Jharkhand so and so 1983 1 GLR bracket NOC 34. Second, opportunity to lead evidence on the issue frame. The evidence given could be recorded in full or summary of the same could be noted, and hearing of the parties themselves all through their lawyer engaged. This apart, some other accepted principle and sound judicial procedure like not allowing a document to be used in the case without the other side having been given opportunity to rebut the same should also be followed when taken up by the revenue member in the first instance or by the chief executive member on appeal. So this is
The last line again. You just read it.
This apart, some other accepted principle, sound judicial procedure like not allowing a document to be used in a case without the other side.
No, even the last thing only when it comes to CM, EM and CM.
Yes, giving opportunity but the same should also be followed when it is taken up by the revenue member in the first instance or by the chief executive member on appeal.
So does it mean that both the authorities should frame issues?
No, either it should be either EM or by the CEM.
So if EM fails to do it, CM can do it.
Yes, he can do it.
And then that will basically correct the mistake of the EM.
Yes.
Is it what is this decision say?
No, the decision says if that either by the.
Just give us. Now tell us. So at least one of the authorities.
One of the authorities should.
EM
It's a mandatory at least by one of the authorities.
If EM fail to do it, then CM should do it, isn't it?
Lordship.
It doesn't say so. It is not for CM to do it. If it is only CM takes up a matter for the first instance, not as appellate authority. So what you say it is not correct.
Here,
it is
neither the EM.
Your matter
Yes.
has originated from EM, isn't it?
Yes.
Your matter started from EM.
Yes.
So it was the duty of the EM to frame issues.
So
So let us come to the
EM.
EM, and then you just tell us that whether that the question of non-framing of issues was raised in the appellate authority or not. And if it was raised, then which appellate authority decided it? 151 you said page for EM's order, isn't it?
Yes, Lordship. That is a CEM order.
CM order. Okay, what is the EM order?
28 12 28 12 2017.
Where is it? That is yes. There is EM order, isn't it?
Lordship.
That is at page 151. 28 12 2017.
Yes, Lordship. This is
Yes.
executive. Yes. This is the order 151.
Yes.
Yeah, may I read it out?
Yes, please.
Heard both sides in detail, referring the direction issued by the Honorable Meghalaya High Court Shillong on so and so, whereby the executive member IC Land and Revenue JCTC Tura directing to decide the respective claim of the parties oppressed after giving full opportunity for putting up their respective cases accordingly, whereby this court has framed issues, examined the witness of both parties, and heard the parties as directed by
See, what
the
does it say?
predecessor.
Framed
Yes, Lordship. That's why, Lordship, on the earlier occasion, this matter was heard, and then in this order, they have reflected the issues were framed,
Yes.
witnesses were examined, both the parties were heard. But in reality, that's why I'm saying that in reality, there is no issues framed.
Yes.
There is no issues framed. The witness were never examined or their statement were never recorded, and parties, of course, parties were heard, but without framing the issues, without recording the statement of the
You say
witnesses.
that no witness examined.
Lordship,
Now
no
this
witness
is-
examined.
So these are all wrong.
This is the all wrong recording of the order.
Very serious.
Because the order only in the order it is reflected, but in reality, while trying the cases, while taking up the cases, there is no witness were examined. There is no list of witnesses, neither the recording of the statement of those witnesses.
List of witnesses may not be there. but
Yes,
then
Lordship. Even then, Lordship, there should be a statement like deposition or any what. Even if there is no deposition, also, even there should be a reflected what witness, who is the witness, and what they have stated. Even in the order is
So
not
it is
there.
not there.
It's
So-
not there. And framing of issues, the framing of issue, what issue has been framed, what are the finding of
You
the
say-
issues.
You say
the-
these issues are not there.
Yes.
That is, I think,
Yes.
precisely those purpose probably records here called.
yes, Lordship, only for that purpose.
Is it correct that there is nothing?
If my lord, can you come to the documents that I have submitted?
Yes.
Classification of relevant records, page 1.
Just a minute.
If my lord, can you see the index?
Yes. Page 1, yes.
Page 1.
Yes.
Both parties are present and represented. Both the parties has filed suggested issue,
Yes.
and issues are accordingly framed. Now this is the order sheet manual, but I have to check the original report whether the order is there or not. Second thing, what my learned friend is saying, that no evidence was recorded. My lord, can you see?
Yes.
Can you see from page 12A, my lord?
Yes.
12A,
Yes.
these are all surrounding dogmas. They have given their statement in their own letterhead. And headman and all the surrounding dogmas they have given. So it may not be a correct.
Way of doing.
Yes, my lord. That to say.
But then evidence were corrected. This
So
is
these
the
are the
form.
statements.
The form of collection may have been different.
Maybe in a different format.
So, but then evidence were recorded.
Yes, my lord. Now, second thing, my lord. Second thing, if my lord, can you see page 10? Page 10. This is the statement given. This is all in Garo, my lord. I don't know what is the content.
Yes.
but it was written by, and Pitendra Sama is the petitioner's ex-husband.
Yes.
So statement of Pitendra as per the
From page 10 till what page these evidences are?
yes, sir, till
12M.
12M. So these are all statement?
This is, your lordship, this is not the statement, this is the document they have just issued stating that Adugachar has no original account. That one actually, and this, whoever give this document, they will never verify the court, and then it is not known who has collected this document, how they have managed to give it to the court, and the court has never dealt with this issue. The court has never verified whether this is whether these people who has issued this document actually in the court of law, your lordship.
You are going too further. We may not inquire into all so many things. But the only thing is that whether this is evidence or this is a document. What
This is not the evidence, my lord.
Or it is document.
This is the just document issued by some other Nokma stating that he has no account. That was whether it can be considered in the court of law, and whether how we will know whether these people are really issuing the document, because they were never brought to the court and they will never be examined. Otherwise, lordship, they should have verified.
My friend, just I want to point out, these statements was recorded by the previous EMI in the first round of litigation. This evidence was recorded. Now, my mechanics come to page 151.
This evidence were recorded. Now, these are not recorded by them.
No, it was given, my lord. It may not be as per the law, but this was given to the EMI.
Now, can it be treated as evidence, Mr. Day? This cannot substitute the evidence.
My lord,
This is not recorded in the form of oral evidence before the authority.
So I totally,
this can at the best can be considered as document.
Yes, my lord. That I have no argument to place, my lord. This is a matter of record, my lord. I cannot even submit anything, my lord, beyond this. But my lord may kindly see 151. If my lord may kindly see page 151 of the writ petition, that is the order. So whether evidence was recorded or not, my lord, the High Court, as per the High Court direction we have disposed of.
Page 151.
Yes, my lord. This is the order of the year.
Page 151 of
the writ petition, my lord. Of the writ petition.
Yes.
Heard both the parties in details, referring the direction issued by the Honorable High Court, Honorable Meghalaya High Court on 27th July 2023 in writ petition number so and so, whereby the executive member in charge land and revenue Tura directing to decide the respective claim of the parties afresh after giving full opportunity of putting their respective cases. Accordingly, whereby this court has framed issues, examined the witness of both the parties and heard the parties as directed by the predecessor. The Honorable Court, the Honorable High Court refer above case number so and so to, and at this motion stage, the respondent JGC are directed to dispose of the matter on the documents and record available in the office after giving full opportunity of being heard to the parties and strictly to follow the judgment order dated 25/5/2013. Refer. No necessary direction issued by the Honorable High Court has been followed after giving opportunity of being heard both the parties, basing on the principle of natural justice as to decide the respective claim of the parties afresh, giving full opportunity of putting their respective case as per the direction thereon. Now here, my lord, the direction was to just to go through the documents and my lord, hearing both the parties. That was our understanding.
Yeah, Dorasangma remains slow. You see, that is a different issue. That you see.
Now, if my lord
the principle laid down in Dorasangma has not been substituted by that order dated 27 July 2013.
Now, if my lord may
so no way it can be interpreted.
My lord, can we come to page 152, the next page, my lord.
Mr. Sangma is sit down. We'll just
Lordship.
You have already made out 2 points. We'll just see. If they cannot satisfy this court, then court will be passing on this.
Now, my lord, we can see After thorough examination of all the documents and record available, the petitioner has submitted and filed all the relevant documents before this court for perusal and comparing studies with that of
That is,
original record.
see, even the document parts also is okay, but then what remains with the evidence?
The evidence was already, my lord, as per my lord, the direction of the honorable court, what we have understood, my lord. A quasi judicial body has understood that, my lord, that we should consider the documents which are available, my lord. That case, the case of the petitioner before the honorable High Court was.
The fact remains that Doresangma directives were not followed. Anyway, that is your interpretation. It's all right. Anything, is there anything to show that oral evidence was recorded? No.
But these are the documents. I cannot, my lord, go beyond the record.
It's all right. It's all right. It's all right. Yes, Mr. Mohanto, you'll say something.
Your Lordship, what Mr. Day
Just
has
confine yourself to that.
only to that. Right?
Issue part, okay, Mr. Day has taken us to that
Yes.
order whereby he said
Yes,
this
yes.
parties are past such issues,
But
and issues were framed. We will accept that, okay, issues were framed.
with regard to
But
the
what do we do with the oral evidence?
Well, they have compared with the original and the document available in the records. And as per the earlier statement given by the neighboring Nokmas or the headmans, whatever you say,
Where are the statements?
Those
The
statements-
is supposed to be given to the authority concerned.
authority concerned, but earlier they have given the statements as per what is submitted from the records. There 18 witnesses were examined.
Where is those records of evidence?
Witnesses, I think Mr. Day has submitted, your Lordship,
No, he has pointed out to the
that letter.
certain
letters.
statement of the parties submitted on their respective letterhead. Now, this cannot substitute the evidence. Evidence means something where you appear before the authority and give your oral evidence.
Oral evidence, but in fact, I don't know if the records will speak
Until
whether-
and unless you adopt a procedure like CPC, where examination chief is submitting
No,
the
I
form.
don't think CPC, it's a
So
customary
here it is
way.
not there.
It's a customary way of dealing
That is
the summary
all
way
right.
of the proceeding they have adopted.
So in if that there is no evidence is recorded, then matter will have to go with.
No, then your Lordship will come to the page number 152. Just your Lordship, the second paragraph. If your Lordship permits me, allow me to read.
Yes.
I have also heard the submission of the counsel, Sri David C.H. Sharma, for the opposition, who submits that he asked this court to adduce the original documents for him and seek time in spite this court of or the consider view that the matter can be disposed of at this motion according to Honorable High Court's direction issued time and again to dispose of the case. The opposite party, means the petitioner again, failed to produce the relevant documents as himself admitted and submitted before this court. This is very important.
That is all right, but then
No,
what about
no,
evidence?
this is very important. Why? Because what from my client, 4 chances were given to them to produce documents and examine their witnesses. No one came.
But there is nothing.
Nobody
to,
came.
Nothing to show.
I think the
examine
records will
witnesses.
speak of your order sheet will speak of
Now
from the
these
record.
witnesses, the statement of witnesses, which Mr. Day just now has pointed out
Yes, yes. Yes.
in his compilation of records. These are witnesses of which side?
Our side, both sides, neighboring.
Who are which side?
No,
And
who are which
which
side we
witnesses are
cannot say.
produced by which
Because,
side?
your Lordship, I do not have access to the record, your Lordship. But what I have
You
gathered,
have received a copy of this, isn't it?
It was supplied to all.
Tell us who were the witnesses of one side and how do we determine how this authority has taken into consideration?
your Lordship, all these witnesses are independent witnesses, neither sides. The EM inches, when they asked all this, they have given the statements. Whether Agu Gotsal,
Interestingly, see, like you say, like if you say, then who brought them to the before the?
are in the records will speak of, I
See,
think,
Mr. Mohanto, there is a way of doing things. If at all some people are examined, their evidence is taken into consideration, at least it should have been reflected in the records. Just somebody's letterhead, somebody's statement.
but your
not
Lordship,
put
in
this
the
as
District
favorable.
Council EM inches, they will not go by the strict rule of the CPC. Your
We
Lordship, that
understand.
your Lordship
We are
knows.
not saying it.
Huh.
Even Doresami also did not say it.
Did not say that.
Doresami said that you either record
It's
the
summary,
evidence
summary way of
or the
proceeding also
summary
can
of
be.
of evidence.
Huh.
But
It is
then-
to be known by the EM inches the facts of the case.
See,
What's the
but then
matter related to?
It was not that you just come and submit, write something on your letterhead and you give, and that becomes evidence. No, it becomes a document, nothing else.
No, but the things, other things, your Lordship, from their side, no documents has been given. As per
That's
my
all right, that is
instruction from my
different.
client, did not produce, neither they examined any witnesses.
Even if you say these are evidences, then we will say this was not done, not recorded. There is no escape from there if that will be.
But whatever the records, whatever the order given by the EM-inches, I have just read, Your Lordship.
Let us come to the appellate's order. What contention they read before the appellate authority?
And another thing, Your Lordship, in page 152, this is important, very important, Your Lordship. Last but the one paragraph, Your Lordship. This court has examined and perused all the documents and records available in the office. The documents submitted by the parties have also compared this 152, last but one paragraph.
Yes.
This court has examined and perused all the documents and records available in the office. The documents submitted by the parties have also compared with the official records available in detail, all the relevant to be noted as observed without any biasness whatsoever in this case by this court.
There is no dispute to this, Mr. Mohanto.
Yes.
We can understand. But
No,
then the very requirement of recording evidence
that
doesn't
oral,
get
I don't
substituted by
think
this.
the counsel is saying they have not recorded the oral evidence. That I have to.
But then see the Dodeswami, what is the principle recorded here?
So whether Dodeswami said the oral evidence to be recorded, Your Lordship.
What is the grounds raised by them in their appeal?
Their appeal.
What is the order passed by the appellate authority?
Appellate authority order, Your Lordship, will come at page 159. Your Lordship. Where Your Lordship is not there?
Yes, 159 is the last page.
159, yes.
159 is the last page of our order.
12/10/2018, Your Lordship.
28/12/2017. No,
this is Your Lordship.
It seems the pagination also is
12/10/2018.
There is some
159 page here is compiled.
It is not here in 159. 159 is a different page here.
This one.
This is their memo of appeal is at page 164 here, annexure 21.
Before that is
And if that way case, Lordship will find 162. That was, he has added few documents twice. That window region income. 162 then.
See, Mr. Sangma, see your memo of appeal, you admitted that issue has been framed. Paragraph 7.
Yes.
But paragraph 7. So how can you raise this ground again? Come to your memo of appeal, come to page 165 of the writ petition. 164 is your memo of appeal, isn't it?
Yes, this is
An appeal under section 8.2 of the Garo Hills Autonomous District. 164.
Lordship,
165.
165 is the second page. 164 is the
page 10.
Come to your memo of appeal. Where is your memo of appeal? Revenue appeal number 1 of 2018.
Yes, 165. Paragraph 7.
Come to paragraph 7. You have stated that you have.
In the case of the party suggests the issue and civil parties should remember was Your Lordship, there is another in the may I just to reply to that one. The record in the page 68, there also another pleading of.
No, that is your own statement, isn't it? That is
Yes.
the party suggested the issues and the issues. Yes, that is your statement. Goes as your statement only. So that is non-framing of issues is no more there for you.
Yes.
Then you do not say in your appeal also that no evidence was collected, nothing, no ground was raised.
Your Lordship,
But the grounds which you failed to take before the appellate authority, can you take it before the Red Court?
No, Your Lordship, what happened?
What is the law in this regard?
No, Your Lordship, of course, the pleading, there is some defect, of course, in the petition. However, Your Lordship, my humble submission, but in reality, there is.
Come to paragraph 16 of your appeal, memo of appeal. See all your grounds. See all your grounds. How many grounds are there? There are number of grounds, isn't it? As many as 10 and 11 grounds.
For that order, ground of appeal shall be adduced at the time of hearing. The appeal is filed within the appeal period of 60 days from the date of passing impugn order dated so and so.
What you are reading?
The appeal ground.
Yeah, that para 16 year grounds, isn't it? Para 16 of your memo of appeal. You got it? You have not gone through it?
Yes, this is yes, Lordship.
You have never come across this document before? Now, if it seems in your memo of appeal, you have not raised any ground.
Yes, this is the ground for the executive member violated the Lordship. For that executive member has violated the.
It's okay. You do not have to read the entire thing. Just show us the paragraph which would be relevant, where you have raised that ground of non-recording of evidence. You have, because
Lordship, ground, Lordship. The impugn judgment and order is illegal, biased, and liable to be set aside. For which original boundary dispute.
Which ground you are reading?
Ground 2.
Yes.
For that, the impugn judgment and order is illegal, biased, and liable to be set aside. For which as original boundary dispute was illegally converted into normative dispute, and the same conversion is not based on original petition filed by the petitioners. Then the second, for that, in spite of the clear direction of the Honorable High Court.
We just come to the relevant part. These are not relevant.
Yes. Now, Lordship, I still want to dwell on the ground 2. Why? Because whatever the document, that another aspect which I'm challenging, which I'm making submission, is they have never considered the document available, whatever document available in the record. That's why I want to take the Lordship.
What are the documents which are not, and which basis we say? Court has said that it has gone to the documents. So you will not disbelieve that. You know that. Your submission will not take you away.
No. May I just submit, Your Lordship, one of the vital document which was submitted by the Majundar during the inquiry. It has not been considered because it was nowhere reflected in the order. Lordship, may I take you to the Majundar report? Even here they have submitted in the Majundar report, my Lord. Verification. It is. It will be in the page 81 to 83, my Lord, in my petition.
In your
81 to
petition.
83. It starts from my repetition, my lord. Even they have submitted even in their report also, my lord.
No, just say confine.
Yes.
You do not go mix up. Page
No,
81 to
page
83
81, my lord.
of your writ petition.
Lordship, page 81. Page 81
Yes.
till page 88. This is
Page
the
81 and page 88. Two matters.
yeah.
Two
Page
documents.
81 till page 88. It's continuation. It is the old Majumdar report.
Yes.
First, this is the, may I read, your lordship?
No, you do not have to read all those things.
Lordship.
So you want to say
Yes.
that this report has not been taken into consideration.
This is never recorded. Yes.
It is
The relevant para I just might to read, page 85. Only page
You
85.
do not have to establish your
Yes,
right.
lordship,
Yes,
lordship.
right now.
This one never considered.
It means this document has not been
Never considered. Nowhere is reflected in the
It was
either
a part
in
of
the
record.
yes. This is the part of record, and even my learned friend they have submitted this document. Even it is in the record also, your lordship.
None of the orders.
None of the order.
EM or the CM.
No,
Take consideration of this.
no, not even a whisper. And my learned friend also submitted in his record. It is page 38 to 63. Same document. Learned friend has submitted.
It's all right.
Yes, but this one never dare with. Not even a whisper.
Okay. This document was a part of record, isn't it?
Yes, this is the part of record.
But in no order, it's not.
Nothing. Lordship.
So basically, these orders passed without taking consideration of this,
Lordship.
without taking any notice of that.
Yes, Lordship.
Yes. All right. Anything more, Mr. Mahanta?
No, those were taken care of, all these documents, Your Lordship.
Where
They're
is
taken
that?
care of.
Has it been?
Yes,
reflected?
then I have to go through the whole order of the EM inches, Lordship promised me.
Is there any specific mention of these things or?
Yes, Your Lordship, the evidence, Your Lordship, this is very important. Even that, what document he is saying, that also is there, I think.
It's submitted.
It is there.
It is there in the record. Index para 14. Serial 14.
See, Mr. Sangma, this says that peruse all the documents and records. Anyway, but then the question of evidence remains.
Then, Your Lordship, before conclusion, Your Lordship, this 153 page of the EM interest order, if Your Lordship.
Page 153, yes.
53, Your Lordship. The case from both the parties have been heard and
Page
gone through the records.
153 of the writ
153, it starts from actually 152.
Yes.
So,
Take it from, yes.
Premises and hearing of the case from both the parties have been heard and gone through the records of the case carefully.
Yes.
On the basis of the evidence so adduced by the parties and office, I am of the opinion that the following observation, that the present Nokma Srimati Nikmi D. Sangma, wife of so-and-so, registered Aking Nokma of Magupara Aking since 26/5/1960, and her lineage descendants from to her in the year 1960 as per GT, genealogical tree recorded available in the official records, having been found there is merit in favor of Srimati Nikmi D. Sangma. The present existing Nokma based on proper application and evidence on records. In conclusion, the Magupara Aking was recognized and approved by the then Deputy Commissioner G.D. Walker in the year 1927 under Aking number 11-15-36 on 19/1/1927. Since then, under Magupara Aking, there are 10-11 major villages existing. So villages. Then your lordship will come to number 8, Roman number 8, Adu Gachil. is a village. It's not a Nagma, Your Lordship.
That is all right.
1
Mr.
minute, Your
Mohanty.
Lordship. As
That is
many
all right.
small
See,
sub-villages and the
you are
present...
going to the merits of the case. We are not on merit.
No, since even the Mozara report, what he's saying, all these are coming from the Mozara report, Your Lordship. So they have considered, therefore it is reflected in the order. It is from the record of the district council it has reported. So in my respectful submission,
How do we know how many documents were considered at the stage of hearing, deciding this matter? Any list of documents made by the...
No, that way...
That has to be...
That way, I do not
Otherwise,
know.
the general kind of order will not do.
No, only the thing the council can show from the records, Your Lordship, what they have shown. From there, we have just, Mr. Samas translated those. All these 18 witnesses, they all are speaking in favor of my petitioner, in favor of me.
They have not spoken, they have given
written. Maybe that is the customary way of the practice, Your Lordship.
So they have not...
No, that is the customary way of practice to summarily deal with this type of situation.
We can understand. See,
yes.
Summary dealing doesn't mean...
No, they cannot, but the strict secrecy rule may not be followed, Your Lordship. In this case, as Your Lordship also knows, though Doresama says the minimum some judicial pronouncement has to be taken care of. So, in my respectful submission, EM Inch's order is really a judicial order. It has taken note of care of everything, Your Lordship. That's my submission, Your Lordship. And this is if Your Lordship desire to remand back, it will be third time remand back, Your Lordship. Because why? Earlier also, that day I read the 2 orders. That order, he just came to the High Court. And they said the earlier order, you follow that. For that basis, that's the second time. Now this is the third time they have come, Your Lordship. So, in my responsibility, it's better we end this litigation. Your Lordship, all the documents has been scrutinized by the district council, available on records, they have passed this order.
But then adherence to law is needed.
No, true, adherence to law. So, to that effect, Your Lordship, the page 30.
To give a quietus to a matter, adherence to law is needed.
I agree, Your Lordship, but we cannot close Your Lordship. They are claiming from 1988. Whereas I am from 1960. That also has to be looked into. Genealogical tree.
Factual aspects, Red Court will not be a proper authority to give.
Your Lordship may not go into the evidence, but what the section 80 he says, Your Lordship, that the genealogical tree he produced, those genealogical tree, only 2 of them, not the predecessors. And this is a village. Sang means is a village. Your Lordship. Sang, they call it. It's a village. It's not a king, Your Lordship. There is no boundary of this. Our king has a deep pillar like this, all the same. Those were discussed here in this
There was a time when they were recognized. It is not that this plus this document, that is that page 81. It is a Adigachoy Naki. And that is written by official of the district council.
Maybe due to that, these documents,
Mr. Mohanto, in any case, this court will not go into the merits of the issue. We are not on that. We are only thinking is that whether procedural part was complied with. That is the main thing. We are concerned with that.
Your Lordship, then again another round of litigation will be followed.
If things are not done properly, who can help it?
Your Lordship, I think the district council is the best judge to do that. 2-3 times they are ready to follow.
No, it is an admitted case that what Mr. Day has produced, that these are not evidence at all. These are all written things. So no evidence. Mr. Sangma is correct in contending that.
I think then my respectful submission, it ought to happen by the Honorable High Court, so that's oral evidence to be recorded. Because this is a customary way of proceeding. They follow the Lineage Act of 1958.
Now, see, Mr. Mohanto, that is page 151, you will find that executive member has recorded, examined the witnesses. Where he has examined witnesses? Is it not a total rewriting? The record is totally contrary. This officer should be made basically liable to answer. How he does it?
Then the order then
is a total distortion of fact.
It should happen clear.
That is not a proper way of doing things. You are holding Doreswamy decision. Come to Doreswamy.
Yes. No, I understand your Lordship. That's it.
Doreswamy did not give a scope for submission of certificate in place of evidence. What is the meaning if something is written on a letterhead and submitted? that becomes a document, a certificate.
So basing on the documents, the EM in charge has passed the order. It used to be framed by the court to understand the grips all the situation, the case.
You can understand,
That's
you can
your
understand.
logic.
But then if there is a judicial
So,
pronouncement, we are bound by that. Or then this court will have to take a different view. But then that is a division bench decision. It's a fine. This court understands what you are saying.
Yes, I agree. So that's
it is not that this court is rejecting your version outrightly, saying that you have no merit.
I have obliged.
But then if the officer concerned does something wrong, which way you can help it? You have seen that the choice of words. See, examined the witnesses of both the parties. Now, if the court says both the parties, who are the witness of which party? Just tell us.
Examined so many witnesses in favor of so and so, that should have been.
This is a normal thing. A record has to be.
No,
we are not saying
agree.
that the CPC you apply make CPC, but then at least some documents are given. It is considered. Then there should be at least which are the documents.
But the problem here, EM in charge, your lordship, they are non-judicial officers. That is under topic also.
But then they are
that's
studying quasi-judicial function.
What is the suffering? Is that topic?
Yeah,
with regard to yes, only with regard to the evidence, your lordship, if that can be looked into by this honorable court.
See, even Doraisamy does not strictly say that the evidence has to be recorded, but then it said that opportunity to lead the evidence. Sure. Now, if you can show that opportunity was given, it was declined, then also we'll accept your submission. But then that has to be shown. And basically, see, that also will not help in view of the fact that, you see, he has said that he has examined the witnesses. No witness was examined. So that is utterly wrong. That can be the sole ground for interpretation. It says evidence given could be recorded in full or summary of the same could be noted.
Maybe the summary here is noted.
Now, if it is becomes a noted, then it is the decision of the judge, not in this way. There is a problem with your prayer in the writ petition. Now, probably Mr. Mohanto had on the earlier occasion pointed.
I have already done that.
For appealment,
no relief can be granted on those.
Only that
Because
that
apart
page is
from
there.
that,
Of
these
course,
are the concurrent findings.
that order passed by the EM.
You yourself, you weaken your case.
Lordship, there is some few defects, of course, I admit, but just because for the
some few defects, sometimes it becomes fatal defect.
But for the interest, because of my defect, the litigant should not suffer. Lordship, that is my humble submission. Okay, I admit my doubt because I admit some mistake here and there, some technicalities.
It is not a matter of admitting or denying. The court is bound by law. You see, your admission will not help. What is the earlier round of the order passed by the High Court? Yes. Not that thing that the
is there. Yes, there's page 1. It will be 159 after that.
The 27/5/2013 is at page 130.
Page 130.
That
is what is needed.
Yes, Lordship, 130. Annexure 14.
Okay. Yes. Order. We'll pass order, Mr. Mohan.
As you wish, Lordship.
Hard. Just record so and so for this. Just see and take note of so and so. Just read him. This is out of a dispute. With regard to the you are agreed by the amalgamation of Adugashi with Magupara, isn't it?
Okay.
What we said just? It is
No, Your Lordship, he is claiming that he is independent king. That's the problem.
Yes, because yes, Lordship is correct. Because
Earlier he was independent king, isn't it?
No,
Yes.
never. He is a villager. Village within
that
our.
is their allegation. I am saying I have the separate account.
Yes, yes.
Now they have amalgate. That make it.
It was not a case that earlier they were separate and then they have amalgamated.
No,
That is what
never.
was
Yes.
argued.
No. The layer seater petition never stated that.
No.
He is living independently.
I am
He is-
independently.
Your Lordship,
account.
please, Sama.
What
Lordship,
do you
your
want?
Lordship will see that what is happening here. He is claiming that Adugasal Aking of another number he produced that he said this.
No.
The evidence of this. Please.
Anyway,
That
it's
is not
okay, it's
there.
all right. It's
No, since Lordship doesn't want to go to evidence, he is beneficiating the document to claim this.
It's all right, Mr. Mohant. We do not want to open to
Yes,
go
yes.
into all those
On
things.
your
This will
house.
not have
That's
help
why,
us
Your
because
Lordship, I'm just,
we are unable to give any finding on those things.
as Your Lordship.
Yes, this code will not.
Then Your Lordship, with the procedural things, Your Lordship's one back may have just played Your Lordship. A time-bound period may be given, Your Lordship. Otherwise, my petitioner is 79, 80 years old. During a lifetime, may not see the light of the day.
What we said? Inclusion of Adugachal is a part of Magupara King. The petitioner's contention is that the Adugachal is an independent king
Lordship.
and could not have been a part of the Magupara king. Give a paragraph. The order dated 28/12/2017 passed by the executive member IC in charge Land and Revenue, comma GCC Tura and what is the other order, Mr. Sangma? This is one order.
12/10/2018.
Where is that?
There is a page 115.
That is what you see. It doesn't tell you. 159 here is different.
It's 151, my lord.
151 is this.
28, 12, 2000.
Is it 12/10/2018?
Yes. Yes, 12, 10, 2018. court
Yes.
by the
What is it? And
Court of
and the order dated 12/10/2018 passed by the just read the right just 12/10/2018 passed by the chief executive member in GHDC revenue stroke appeal number 1 A capital S stop capital C stop of 2018. You will get it at 159 page 159 are under challenge in this writ petition. Stop by the aforesaid by the aforesaid orders the Adiga was held to be a part of Magupara Akim. Stop. Paragraph. Sit down, Mr. Shan. You stand up when court dictates something wrong. Yes. The learned counsel for the petition strenuously argues that Adigachal was never a part of Magupara Akim. And the same could not have been included in the Magupara Akim by treating as a village. It is a contention of the learned counsel of the petitioner that the petitioner that both the authorities of the district council, both the authorities of the GHDC while deciding the matter you do one thing, do not say both the authorities, you just say it is the what you said, it is the for the petitioner that the executive member while deciding their dispute has not taken into consideration the established legal norms and gone ahead to decide the matter without framing any issue, examining evidence of any of the witnesses, and also considering the relevant documents on record. The learned counsel has heavily relied on the decision reported in 1988 to GLR 137. No, it's not 137. It's 120. Comma, Srimati Dore Sangma and others versus, you get it from here, versus CEO, comma, GHDC, Tura and others. What you said? The Learned Council is heavily. And submitted that the direction made therein with regard to the framing of issues, comma, recording of evidence, and consideration of documents have been totally overlooked by the executive member and the authority thereby came to a wrong finding. Stop. It is also submitted by the Learned Council for the petitioner that the chief executive member, while deciding the appeal, has also acted mechanically and upheld the decision of the executive member without appreciating the established norms of law. Stop. The Learned Council submits that since both the authorities of the district council has not discharged their duty in deciding the matter strictly in accordance with law, comma, both the orders dated so and so and so and so are liable to be set aside and closed. Stop. Your paragraph. Per contra, Mr. Day, you are appearing for us. One number? You are 1, 2, 3, and Mr. Mohanto is number 4. Okay, Mr. S. Day. Per contra, Mr. S. Day. Learned Council for the respond number 1, 2, and 3. Defeated the submission of the petition and submitted that all the procedures all the norms and procedures were followed by the authorities while deciding the matter. The Learned Counsel has taken this court to the record of the GHETC and pointed out the relevant order by which the issues were held to be recorded, held to be framed. Issues were recorded to have been framed by the stuff. The Learned Counsel has further drawn the attention of this court to certain statements submitted by some witnesses on their respective letterheads and submitted that the requisite evidences were also recorded in the matter. He further submits that all the relevant documents were also considered by the authorities of the District Council and hence the writ petition is devoid of merit and liable to be dismissed forthwith. Next paragraph. Mr. S.P. Mohanty.
One more point can be added by the sport. This 147, we have seen whether we have strictly followed the order of the Honorable High Court.
Yes, just before that, in the last paragraph, it is also the submission of the Learned Counsel that the direction basing on which this matter was taken up by the authorities of District Council where the direction dated, just a minute,
Dated 26/8/2016. 26/8/2016. Page 146.
that is the order of Justice Shen.
Yes, fine. By the prayer of the petitioner, that is the present petitioner, that case
Yes.
dispose of as per
Just this also. What is it? This direction dated 26/8/2016, passed in WPC number 215/2016. Was taken into consideration by the District Council authorities and the directions and the said directions were and the matters were and the matter was decided in compliance of the said direction of the High Court. That is all right, Mr. Is that
Can
all
I
right?
just add that one minute? Their direction means the council admitted that will go on the basis of the records available. That is the most
That is
emphasized.
okay, but whatever direction, that is what is his submission. He said the direction has been complied. That is what we have. Yes. You have to stop the paragraph. Then come next paragraph. Mr. S.P. Mahato, London Senior Counsel. Assisted by Mr. L.M. Salma. If you on the top, if you say so and so assisted by so and so, then you do not have to repeat it here. Okay, just adjust those parts accordingly. Okay, submits that the orders of the executive member as well as the chief executive member were passed totally in accordance with, strictly in accordance with law, and the authorities have meticulously taken into consideration the evidences and documents which were available before them. Stop. The learned senior counsel has taken this court to the respective orders passed by the district council. No, to the order of the executive member. To the order dated 28/12/2017, just it is better. You just say to the order dated 28/12/2017 of the executive member. You see, wherever you say executive member, just comma IC land and revenue, just right. Huh? And pointed out that the petitioners have miserably failed to produce any relevant document before the said authority. It is also the submission of the London Senior Counsel that the decision rendered therein is entirely on the basis of the evidence so adduced by the parties. And also the document and also the official documents available in draft. The London Senior Counsel further contends that Adugachal was never an aking by itself and was a village all along, falling under Magupada Aking. It is a submission of the London Senior Council that the entire contention of the petitioner before this court is devoid of merit, and writ petition deserves to be dismissed forthwith. Stop. Yes, sir. Pardon. Yes, upon hearing the next page, upon hearing the learned counsel of the parties and on perusal of material of records, it is found that the learned executive member, while deciding the matter by order dated 17/12/2014, has recorded that both the parties are present and have filed suggested issues, and the issues were accordingly framed. Stop. It further appears on the record that the that the landed executive member in order dated 20/12/2017 recorded that witnesses of both the parties were examined by his predecessor in the office. Stop. However, on perusal of the record, it appears that no statement of the witnesses were recorded by the executive member. Stop. The materials on record which are pointed about the learned counsel of the GHDC are not record of evidence, but are all are written statement issued in the form of certificate on the respected letterhead of the of the respective letterhead of the witnesses. Stop. Give a paragraph. You say the decision of Doresangma and others. Decision of Simoti Doresangma and others, within bracket you write supra, at paragraph 20 lays down the following. Then give a colon dash, then record this paragraph 20 from here. Give a paragraph from these things. What emerges from the above? What emerges from the principle laid down in the Doresangma case is that the revenue member has to follow the fundamental principle of judicial procedure by framing issues which have been regarded necessary and also to provide opportunity to the parties to lead evidence on the issue framed. On the issues framed. Stop. In the present matter, there is nothing on record that parties were given opportunity to lead evidence. Although the order of the executive member recorded that the witnesses were examined, there is nothing on record to show which witnesses were examined and from how many witnesses were examined and from which parties and from which party. The statement, the records of statement pointed out by the learned counsel of the GHDC also cannot be considered as a piece of evidence, as those are not recorded on the physical appearance of the witnesses. As those are not recorded after securing physical appearance of the witnesses before the concerned authority.
Lordship, we prosecute making oral evidence. So that
physical appearance means that has to be oral.
I think maybe Yamichas may not know that.
That will see. You will be there to explain that. Anyway, we are not saying,
Yes.
we have not come to the direction part till now. We
Yes.
are just saying that what is happening. What is it? As a piece of oral evidence. As a piece of oral evidence. after securing physical presence of the witnesses. Physical presence of the witnesses. Hence, it can be concluded that the executive member has not what is it? Hence it can be decided the matter by following the mandate of law as per the decision of Dorisami Supra. Next paragraph. The perusal of the order dated do not say a perusal, just say perusal. Just a perusal of order dated 12/2018 of the appellate authority of the chief executive member in GHDC revenue stock appeal number so and so of 2018 also does not show that the appellate authority has dealt with the issue of a recording of evidence in the matter. Stop. Of course, it is not clear as to whether the petitioner had raised the issue of non-recording of evidence before the appellate authority or not. What is it? Of course. Huh? Or not, comma. But since it's a mandate of law that the district council authority, since it is a mandate of the law that the just last thing the district council that the executive member, come on, in charge revenue, come on, district council shall decide the matter only after providing an opportunity to the parties to record evidence. Come on. The order of the appellate authority also cannot be held to be an order passed in accordance with him. Stop. Give paragraph. Then you say, in view of the discussion above, in view of the discussion made above, the order dated. What is the order? Order dated 18/12/2017, passed by the executive member in charge revenue GHDC, Tura in what is the number of the proceeding number? Where it is available? What is the number? 150. Acha. See, this is handwritten. Page 150. You will find it. It is handwritten. Huh? Just try to get it from here. Case number GHDC revenue AC 35. Page 150. Okay, you have to get the number. Acha, order date so and so so and so. And order dated 12/10/2018, passed by the chief executive member in GHDC revenue appeal, that you will get in page 159. This number are hereby set aside and closed. The matter shall stand remanded back to the executive member in charge revenue GHDC for a decision, for taking a decision afresh strictly in accordance with the mandate of law laid down in Dore Sangma case, Dore Sangma, Simoti Dore Sangma and others, the first case. Stop. Needless to say that the parties will have their respective remedies open in the event any of them feel aggrieved by the decision made by the authorities of the district council. Stop. Next paragraph. It is made clear that this court has not gone into the merits of the contentions, merits of the factual aspect of the matter. Stop. The district council authorities shall be at liberty to decide the matter after determining the merits basing upon the contentions raised by the respective parties. Next paragraph. With the aforesaid, this writ petition stand disposed of. No order as to cost. Yes.
Lordship, only one prayer that the disposal, the year mentions, maybe a time-bound period, Your Lordship.
See, district council remains under strike sometimes. This is very these things.
No, I understand, but
My lord, it will be difficult.
Definitely.
Otherwise, again, my lord, they will come with the contempt petition. It will be very difficult.
We'll not this thing. We'll just say that endeavor should be made.
endeavor to expedite disposal.
Just before we just say, with the aforesaid, before that we just say an endeavor should be made by the district council authority to dispose of the matter as early as possible.
Yes.
Preferably within 4 months or 6 months.
Impossible, my lord.
They will come for contempt.
No, preferably then contempt would not lie.
No, you see, it's up to you which way you proceed also. There may be a bit correction change here there. Sometimes we repeat things, so this will be taken care of.
Mr. Dey should advise to take the oral evidence. I think. Yes.
Mr. Day is there too.
Therefore, I just request him.
I have no comment on that.
Anyway, obliged.
He will discharge his professional duty the way the situation demands.
Yes. Since merit has not gone into end. Therefore. Anyway, deeply obliged.
Item number 6.
Matter, Your Lordship, this item number 6, Your Lordship, what happened
Yes.
actually I find appeal because now the petitioner that he's inside the jail, language in the jail. I have called upon the relatives. Actually, there is some order has been passed by the session court. So I'm yet to obtain that order because I don't know what the order had been passed exactly. So I called because there the relatives are in Punjab, and this petitioner is in language in the jail. That's why it's quite difficult to get a correct picture of the order. That's why I'm praying
So
for
we'll
some time.
dismiss this petition. When you get the
Lordship,
correct picture, then we will
yes,
file it again.
either I may withdraw because now without any instruction from the litigant, I cannot just withdraw it also
cannot
because it's not good on my part also.
You want
Lordship.
material instruction.
I have called the relative just to get the order so that I can assist the court in better way.
So what do you want us to do now?
No, you just kindly give me some time. That matter may.
Hine has objection. He is not at all in a mood to.
No, Lordship, I don't know if they have the order. They can provide me. I will go through that order so that I can also.
Order. You have any knowledge of passing of?
I have a copy of the order and judgment of the Sessions Court.
Yes.
The Sessions Court had already upheld the decision of the trial court CGF. And now,
And
as per the
this is a case what seeking quashing
quashing.
or the
So,
proceeding
actually-
pending before the trial court.
yes, Lordship.
So it means they approach this court before the trial court pronounced its decision.
The quashing petition, they approached this court
Before the trial court decided it.
before the
For the session court.
the appeal, before the
This
appeal
is-
has been
just a
decided.
minute.
Appeal was pending actually.
What you are challenging? You are challenging a proceeding before which court?
Yeah, there's actually the here only to because we are coming on the way of compromise. Both the party actually compromise
fine.
was done while the case was pending.
There is a decision of the Supreme Court. I think it was placed earlier at the
Yes,
time.
yes, Lordship.
This cannot be
And also a criminal revision has been filed before this honorable court, Lordship. So this
challenging the conviction.
the conviction order passed by the
And then there
learned
is pending
sessions
here.
court.
That is pending. That revision is pending here.
Yes, it's yet to be listed for motion, Lordship.
So this
So-
conviction is by which court?
The learned sessions court. The learned sessions court has upheld the order and
So
judgment of
that
the
means
trial
this
court.
case basically started from a magistrate court,
Yes, Lordship.
isn't it?
Yes,
So the court of first instance convicted him.
yes. And the learned sessions court upheld that decision.
Now
of
just
that.
now please clarify whether this quashing application was preferred prior to the conviction recorded by the court of first instance or after.
after.
But then they did not say that it was. They disclosed that they have been convicted.
We have disclosed that the petition was pending. The first conviction order was being challenged. That was pending.
You say in this
yes.
thing that you were convicted.
Yes, I have
here.
mentioned. I have mentioned. I have convicted.
Where you have mentioned?
Yes, Lordship. In by far I have mentioned. Lordship, the police listen to hearing page.
Judgment already 20
examined. During the pendency of the criminal appeal, Lordship, the para 6 is there, Lordship.
Para 4, what is para 4? Para 4, what
Para
is
4, that the Chief Judicial Magistrate, after examining report 6 prosecution witness and after recording the statement
Yes.
of prosecuting
Yes,
witness.
you have stated. You have
Yes.
stated. You have stated.
I've said it.
So, thereafter you entered the compromise.
Yes. Well, the appeal was pending before the court of district session judge. There was a compromise
Now-
by the parties.
Now the session judge also is upheld.
Yes.
I have a copy of that judgment and order
Yes.
of the sessions.
So, but then that is okay. But then this will it be very relevant if the apex court says that after conviction you cannot compromise, cannot be given credence.
Because that one. No, actually,
Let
Lordship.
us dismiss it.
Lordship, because now the what happened is case now the contention of the prisoner herein is because now the victim has come forward and compromising that she has filed a false FIR against the That means he is forcefully.
No, 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 no. That is not compromise. If that be the thing, then we'll see it. Have you challenged the order of the session court?
Because that
Have you challenged
order
the
is
order of the session court? Anyway, you obtain instruction and then
Lordship.
you can get back to
Lordship,
us.
because
Because
as
you
per,
see, otherwise, I think this compromise cannot be acted upon, isn't it?
let me get the order, Lordship.
You are
Just give me
appealing
some.
And then what you are supporting his case.
Lordship, as per
It's for
my
the victim. For victim.
What is the sanction, section
354.
354?
Actually, I was alleged that I alleged of rape, but then they were convicted not on that one, but it was convicted only the punishment is only 1 year. That order was there. See the criminal appeals patient.
But then this apex court decision is against you, Mr. Sangma. This court cannot help you.
And moreover, since a criminal revision has been preferred against the order of the learned sessions judge, so this petition will become infructuous as per me.
I will get the instruction, Lordship. I will just withdraw it, or but just I will have a talk with the relatives, and then let me also go to the order. Obviously, I will withdraw it, or I will not pursue. But it is good.
Anyway,
I just
it is submitted by. Yes,
In fact, Your Lordship, what happened, Your Lordship? The order in which he has been convicted, that has been upheld by the
yes, yes.
learned session judge, Your Lordship.
You submitted on the last occasion, and then said there is a apex court decision which says that. The
Lordship, in
compromise.
fact, I have that decision is here with me. In fact, I have Lordship is a very. I have also.
That is all right. That is all right. The only thing is that, see, Mr. Sulai,
Lordship.
Mr. Sangma wants some time because he says that he might withdraw this matter also. He is waiting for appropriate instruction. So let us just.
yes, Lordship. I will just get the instruction. Let me go to the order also, Lordship.
Yes. It is submitted by Mr. P.T. Sangma, learned counsel, to the petitioner that there are certain development in the matter. And praise for grant us some time to take appropriate instruction. The learned AG appearing for the state has no objection. Trial allowed. Distracted 2 weeks.
Lordship.
You take instruction.
Yes, yes.
Then
next date I will.
Otherwise, also you do not have a case.
Yes, yes, Lordship.
Either you withdraw or we dismiss.
Yes, yes. yes
Choice is yours.
yes. As well as Lordship.